Hello, welcome back to another video. Tis I, Dollar Store Nuxanor, and today we got something new, something different. We got, goddamn, that's annoying. We got Supreme Court issues 9-0 unanimous decision changing the Second Amendment and constitutional fight. So yeah, let's get into it.
Imagine that you're driving home one night, you have music blasting, maybe a little too loud, and then you see some flashing lights in your mirror, but instead of pulling over immediately, you kind of pull into your home that's just a couple seconds away. You pull into your garage and you decide to close your garage door. And then suddenly, out of nowhere, the police officer decides to enter into your garage and come into your home. The question is that legal? Well, in a 9-0 unanimous ruling by the Supreme Court, they found that the law enforcement officers and those actions did violate the Fourth Amendment. So let's break.
Yeah, that's an unlawful search and seizure. They don't have a warrant, then they have no right to enter your property. Like, what? That's good. That's actually really good. Like, holy shit, dude. Because, like, you see so many clips of police doing that. Like, shit, dude. I literally saw a short the other day of some dude literally just chilling in his garage with his motorcycle. His motorcycle, he was either warming it up or it wasn't on. I don't remember. It was one of those two. And the cops literally just walk into his garage and they start questioning him and trying to charge him with shit. And he essentially tells them to fuck right off because they're entering his home illegally. And the fact that cops are that comfortable with breaking the law and breaking your Fourth Amendment right to unlawful search and seizure is just mind-boggling to me, dude. It's like, what the fuck?
Down what happened in this critical case. Now, before we jump into this video, I want to thank the sponsor of this video, which is Attorneys on Retainer. When it comes to protecting yourself after a self-defense incident, AOR is in a league of their own. AOR is backed by an actual law firm, the Attorneys for Freedom, and they will help you in self-defense incidents that maybe other companies would not. For example, they can help people in states like New York and other restrictive states, and they've won cases for their clients in those states. And one of the really cool things about AOR is right now they've expanded their benefits so you can get, added benefits, no extra cost to you this year if you sign up. If you want to get what in my opinion is the best coverage on the market, check them out using the links down below in the details section and also in the pinned comment. And if you sign up using my code ARMSCHOLAR, you can get $50 off of your individual plan or $25 off of a family plan. As I mentioned in the intro, in this video, we're going to be discussing a 9-0 unanimous decision issued by the Supreme Court, which involves your rights to prevent law enforcement officers from entering your home without a warrant. The Supreme Court decision that we're talking about in this came in a case called Lang versus California, and it's important because
Of course it was in fucking California. Of course it was in California. Why wouldn't it be in California? The state where the innocent are arrested and the criminals are allowed to walk free. Who would have fucking guessed, man? Who would have guessed?
it rejected the idea that police officers can automatically enter your home without a warrant whenever they're in hot pursuit. Instead, the court here required a case-by-case analysis, emphasizing that the home is at the core of the Fourth Amendment. It has special protections, and your home is your castle and should be treated different. For gun owners, this ruling is highly relevant today because many firearms-related offenses, such as technical violations of potential storage, transportation, magazine laws, and others, are classified as actual misdemeanors in those states, and they have those types of
Bro, this is why I fucking hate this state, dude. They quite literally will do everything in their power to fucking take your rights away when it comes to owning guns. Like, holy shit. They will do anything and everything in their power to violate the Second Amendment to the maximum. And it's so stupid, man. The fact that, that they allow these fucking laws to be in place that restrict your shit, it's like, bro, it's so stupid. It's like, oh, you can't have a magazine of this size. Oh, you can't have this kind of weapon. Oh, you can't have this. You can't have that. It's like, bro, What? Like, dude, you fuck off, man. Genuinely, dude. As someone who's a huge advocate of the Second Amendment, California needs to fuck right off with all these restrictive laws. It's so stupid, man.
Restrictive regulations that potentially could open the door to law enforcement getting into your home without a warrant. This case strengthens your privacy rights and ensures that the Fourth Amendment protections that you have within your home are actually strong and don't get eroded by these types of actions. Now, in this case, the individual Arthur Lang was driving home. He lived in Sonoma, California, and this happened back in 2016. He was playing music loudly, and I believe he was also honking his horn for no apparent reason. Maybe he was getting too excited because of the music. I don't know. But this behavior drew the attention of a California Highway Patrol officer. The officer decided to follow Lang, so he did not immediately stop him. He didn't flash his lights immediately. Instead, he followed him for a while. And by the time that Lang was actually pulling into his driveway, the officer had decided to turn on his lights and signal for him to stop. But again, he was already in his driveway pulling into his garage.
Bro, that's so fucking scummy, dude. Like, bro, this is why people fucking hate the police. They'll do shit like this. Like, this is why people advocate to defund the police. It's because you have officers like this who will quite literally waste their fucking time and it will essentially tail you until you reach a certain destination, and then they'll essentially try to enforce their authority and enforce their power over you over the dumbest fucking things. Like, holy shit, dude. Like, last I checked, playing music loudly in your car wasn't against the law. Like, it's so stupid, man. Honking the horn, maybe, sure, you could say you're disturbing the peace and shit. But like, playing music too loudly, who constitutes too loudly? Genuinely, like, who dictates what is too loud and what isn't too loud? It's the dumbest thing in the world, man.
And once he got into the garage, he decided to close the garage door. The officer quickly decided to get out of his vehicle and, went into the garage, stuck his foot under the sensor, stopped the garage door from closing, and entered into the garage. Once he was in there, the officer questioned Lang. He believed that he smelled alcohol and eventually charged him with driving, under the influence. Now,
If you were how here's my question: if you've been tailing them for that long, why didn't you pull them over while they were still on the road and do a field sobriety test? Why did you wait for them to be in their home to do that? To charge them with supposedly driving under the influence? That's stupid as shit. That right there should be illegal, in my opinion. Like, it's so stupid, man.
here's the problem: the police officer did not have a warrant to enter into Lang's home. And under the Fourth Amendment, your home is where privacy rights are at their strongest. So the legal issue in this case boiled down to this issue: does the pursuit of someone suspected of committing a misdemeanor automatically justify a warrantless entry into your home? The lower court on review actually said yes. They ruled in favor of the law enforcement officer. They relied on what is known as the hot pursuit doctrine. The doctrine allows police officers to follow.
But the issue is that wasn't a hot pursuit. A hot pursuit entails that you had your lights on and they didn't pull over and they kept on driving no matter what, and then they got home and then they tried to, bar themselves in their home to try to avoid arrest. That's not what happened, though. What happened is you tailgated this dude without any justification, and the moment that they actually pulled into their home, that's when you decide to flash your lights and try to instigate something. It's bullshit. It's utter bullshit, and in my opinion, that's just straight up abuse of power. Like, holy shit.
A fleeing suspect into a private place like a home without first getting a warrant. However, historically, that doctrine was applied only to felonies, not every kind of minor violation like playing music too loud in your car. The California courts on review ruled against Mr. Lang, saying that because he did not stop immediately and drove into his garage, the police officer was in hot pursuit and therefore could enter.
But he wasn't. He wasn't, though. He quite literally wasn't. He didn't turn on his lights until the dude was in his driveway. That's not a hot pursuit. In no way, shape, or form could you, in your right fucking mind, say that that is a hot pursuit when you flash your lights literally once they're in their driveway, pulling into their garage. That's utter bullshit.
Into the home without a warrant. Mr. Lang appealed that ruling and he argued that this rule gave police too much power. And he said that if any misdemeanor, no matter how small, justified coming into your home, then the Fourth Amendment's protections really, within the home was almost meaningless. This issue eventually made its way to the Supreme Court back in 2021. And in a 9-0 unanimous decision issued by the Supreme Court, they ruled in favor of Mr. Lang. The court answered this question, and it was a very clear answer. They said that there is no automatic rule that hot pursuit of a misdemeanor always allows the warrantless entry into the home. Instead, they said courts must look at the totality of the circumstances. Sometimes, exigent circumstances like an emergency or a threat to public safety or the risk of maybe evidence being destroyed will actually justify entering the home without a warrant. But the mere fact that someone committed a misdemeanor does not automatically give the police the power to enter the home. It should be looked at on a case-by-case basis based on the totality of the circumstances. The court was unanimous in rejecting California's broad rule here, although there were some concurrences where they reached the same conclusion but kind of came to it by a different approach. However, it was still 9-0 in favor of Mr. Lang. Now, the key takeaway of this is that the court struck down the whole, blanket exception that was applied here in this case and reaffirmed that the home is entitled to special Fourth Amendment protections because it's your castle, it's your home, and it should be treated different. Now, why is this Lang case still important, especially for gun owners today and anyone concerned about these type of constitutional rights? Well, the court reminded us that the home is treated different under the Fourth Amendment. Whether you own firearms or not, this ruling reinforces the idea that the government can't just walk into your home because of minor violations or beliefs that maybe you committed a misdemeanor. Without this,
That's good because, like you showed at the start, California has a whole bunch of rules when it comes to guns and whatnot that would be classified as misdemeanors, and it's like, well, if any suspected misdemeanor could warrant an unlawful entry into your house, well then, like you said, what's the point of the Fourth Amendment then? There is no point because, but if that's the case, I suspected that they had without any actual probable cause. I suspected that the individual had some. I saw that he had a hunting rifle mounted on his fucking wall in his living room, and that led me to suspect that this individual might have modified attachments for his weapons, even though the only weapon you saw was a hunting rifle mounted on the wall with no actual clip attached to it, just the bare bones hunting rifle. It's like, what? That makes no sense. Why do you gotta just enter my home just because you saw a hunting rifle and you suspect that I might have, a different gun that might have a magazine that's too long? It's stupid. It's genuinely stupid, and like you said, it gives the police way too much power and way too much authority when, at the end of the day, the police are quite literally just civil servants. It's like, and sometimes they quite literally let the power go straight to their head. Like, it's fucking insane, man.
ruling, police could have claimed a free pass to enter anyone's home whenever essentially someone is maybe suspected of committing a misdemeanor. And remember, most crimes within the United States are actually classified as misdemeanors. That includes things like noise violations, traffic infractions, or minor licensing offenses. And when it comes to the gun context, a lot of the laws that are written in restrictive states like California, they are actually classified first as misdemeanors. This Lang ruling ensures that these types of law enforcement officers can't use this type of automatic excuse to enter your home and then potentially also search your home and potentially also confiscate your firearms. This ruling also lines up with other cases that we've talked about in the past, like the Caniglia versus Strom case, which also rejected the whole broad community caretaking entries into the home without a warrant. Together, these create a very clear pattern where the court is unwilling to water down the Fourth Amendment when it comes to your private dwellings and when it comes to your home. This precedent also bodes very well for the upcoming Fourth Amendment case that we've talked about, which is the Case versus Montana challenge, which also deals with the warrantless entry into the home. The Supreme Court is currently set to hear oral arguments in that challenge in October, and that ruling could further solidify these types of Fourth Amendment protections within your home. So the Lang versus
That'll be really good because holy shit, man. Like, being able to enter someone's home without a warrant just because you suspect them of committing a misdemeanor is absolutely wild to me. Like, holy shit, dude. Talk about a massive, like, they're probably going to do the exact same thing. My prediction is it'll probably be another 9-0 unanimous in favor of the defendant, and it'll probably, like he said, solidify this even harder, that, you know, just because you're committing a misdemeanor does not give the police any right to enter your home without a warrant. Because it genuinely is a dumb law. It genuinely is a dumb thing when you think about it. Like, oh, you can just enter my home willy-nilly just because of any misdemeanor, even if it's something as simple as like a slight noise complaint, a noise violation. Like, it genuinely is dumb. Like, no no entity should have that much power and that much authority to just be able to enter your home willy-nilly and then just be able to search your house just because of some ridiculously minor misdemeanor, like potentially like a noise complaint. It's so dumb.
California case maybe not have gotten as much attention and coverage as it should have, and it's, you know, maybe didn't get as much attention as some of the blockbuster Second Amendment rulings, but it's very significant and it's important for all gun owners to actually know about. It closed the door on a dangerous expansion of government power and reaffirmed one of our bedrock principles when it comes to the American law and what our founders believed. That is essentially that your home is your castle and you should be safe from governmental intrusions into your castle. So for gun owners, this unanimous decision is still very relevant today and could also come into play during that Supreme Court's upcoming review of the Case versus Montana challenge, which seeks to expand upon Knigley versus Strom in that 9-0 decision, and these prior cases like this one, Lang, which came before it, which said that no, the government and law enforcement cannot enter your home without a warrant under these types of exceptions. So this is a great case. I wanted to make you guys aware of it. It's a great ruling that everyone should know about, especially gun owners. So if you have any questions, go ahead and comment down below and I will try to answer to the best of my ability. If you like this video and you would like to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have a lot for you guys, channel merch, deals, coupons, all of that. And you can also check out my free legal guide that I have available for you. I'll leave that link down below as well. All you have to do is put in your email and we send you over a free PDF. We do some follow-up emails of educational information and then some daily deals as well to save you some money.
Ooh.
But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars and this nation will be maintained by armed scholars.
Ooh, deals and coupons. Let's go. We love coupons. I wonder what those coupons would be for. But yeah, like, this is actually really good. Like, this is really good because it'll essentially not allow cops to just come into your home without a warrant, just because you might have like modified certain things in like the state of, like, for example, California, when it comes to the Second Amendment and it comes to your rights to bear arms. They might say, oh, well, you might have this extended magazine and whatnot in your house. That's justification. It's like, no, not anymore. Not anymore. As to this ruling, that's not justifications enough, because that's a misdemeanor. And it wouldn't really allow them to just outright willy-nilly enter your home just because they're feeling like going on a power trip and enforcing their own, and enforcing that power on the individual. But yeah, good video. I enjoyed it. I liked it. Very informative. Of course, it was fucking California, but you know, the fact that there's another one coming up in October really just goes to show how a lot of people, regardless of what state they're in, will just try to violate your rights. But yeah, if you enjoyed the video, like, comment, subscribe, and all that YouTube jazz, and I will catch y'all in the next one later.